Hello, everyone, and welcome to the LibertyCon 2021 virtual panel on the regulation of space activities. I'm your moderator, Les Johnson. I'm not a space lawyer, but I am a space technologist, a science fiction writer, and writer of popular science and science fiction who sets a lot of his stories in space dealing with issues that where conflicts have arisen between competing space powers, legal questions about space mining, international policy and international space regulation, all of that play into it. And the future that I think most of us want to see in the exploration of development in space is going to be one where we have not just nation states, but individuals and companies venturing out into the great beyond. And the inevitable question arises, who's in charge? What laws apply? How are things regulated? How will governance happen? Those are all really good questions. And with this panel today, I'm hoping we can get some insight into where we're going in terms of answering those questions and maybe actually answer a few of them. We have two panelists. I'll let them introduce themselves here in a minute. The first panelist is Laura Montgomery. The second one is Art Dula. And I'll start out with Laura. If you can introduce yourself and tell a little bit about your background and about your participation in this panel.
Sure. Thank you, Les. I'm really excited to be on this panel. Thank you for including me. And to be here with Art is a real privilege, so I'm kind of excited. I am a space law attorney. I practice through my firm, Ground-Based Space Matters, where I have a blog as well. I also teach space law at Catholic University's Law School. And before that, I was with the FAA for 22 years, where I worked with worked in the Office of the Chief Counsel, but the main client, as it were, was the Office of Commercial Space Transportation. And I supported them in their regulation of launch and reentry. I worked on regulations dealing with everything from how to destroy expendable launch vehicles to launch safety during lightning storms to human spaceflight regulations for space tourism. Since I left the FAA, I have testified to Congress 3 times on the international obligations of the United States under the Outer Space Treaties. I too write science fiction. Some of it, about half of it, is bourgeois legal science fiction set in the near future, and the other half is space opera. And even though it takes place on planets, I have a legal argument as to why it is still space opera, which I will tell you someone in person who is ever interested. Anyway, that's my background there.
I've never heard anyone justify space opera as a legal argument, so I'll take you up on that when I see you next, hopefully at the Interstellar Research Group Symposium in Tucson this fall. Yep, that'd be great. All right, I'll turn it over to Art. Art, would you introduce yourself and give a little bit of your background?
Well, thank you very much, Les and Laura. I'm delighted to be with you today, and I'm honored to be working with LibertyCon, which has to be one of the funnest things I've ever done. I must give kind of an apology. Other than this con, I've never done anything virtually before. So if I sound a little scatterbrained, it's because I'm used to doing things in person. I'm a patent attorney. I'm an intellectual property attorney. I have a degree in civil law from Tulane University, which teaches kind of a European codal law that comes from the Roman law, the Roman civil law. So it's a little different than common law and the law of England, which most schools teach. I went to law school to become a colony administrator, probably on the moon. Unfortunately, we didn't get there. To find something else to do. And while Laura approaches things from the government side with the FAA and her practice, I tended to approach it from the other side by starting companies. I started an engineering company that launched the first private space vehicle from the United States. And this was in 1982. It was the Conestoga rocket. It went about 250 miles. That was launched from Matagorda Island, Texas. And I did all the legal work on that one, from forming the company We didn't have to get a launch license back then. The law hadn't been passed. So I think I had to comply with the fireworks ordinance. But after that, I started a few other companies. One of them was SpaceHab, which put essentially a Winnebago camper in the back of the shuttle to give you some extra pressurized space. It did the largest private capital raise that had ever been done for a space project. And it did fly successfully many times. It finally went public, and of course, everybody made some money on that. I then started selling Russian rockets, and I actually sold the first Russian proton rocket to Hughes. And I worked with the Russians for 22 years while they formed a space program and tried to learn about capitalism. And then I went and helped worked for 10 years with the Chinese space program. All of this while I was practicing patent law in aerospace. I also taught space law at the University of Houston for 22 years. So I've had a lot of fun. So why don't we get to your questions, Les?
Sure. Boy, with this background, I hope I don't know if we'll be able to stump the panelists or not. So I'll start out with with a pretty straightforward one, though. Laura, I'll start with you. Where is the status of current regulation? What U.S. space activities are currently regulated, and who does that regulation?
Well, there are 3 regulatory agencies in the United States that oversee and require licenses for the 3 different space industrial sectors. So taking them alphabetically here, the Federal Aviation Administration has a small office, it was about 70 people when I left, it may have grown, that regulates launch and reentry vehicles, rockets, and the capsules that come back in. So SpaceX, for instance, needs an FAA license to take up the payloads that it does, both to go up and to come back. One thing that people need to be aware of is that although FAA has transportation, it doesn't have on-orbit authority. So once something has reached orbit, it is outside of the FAA's jurisdiction. And but the big satellites, and the smaller ones as well, are regulated by 2 other agencies. So the Federal Communications Commission oversees the satellite industry. Anyone who is transmitting into the United States needs a license to operate its satellite. And that includes the big satellites in geostationary orbit, as well as the smaller LEO constellations in low Earth orbit, and down to some of those little teeny CubeSats, the 10 by 10s. So then the 3rd agency that regulates commercial activities is NOAA, the National Oceanic and Atmospheric Administration in the Department of Commerce. So if you are taking pictures of your home planet or otherwise engaged in, this is the technical term, remote sensing of the Earth, you're capable of engaging in remote sensing of the Earth, you need a license to do so from NOAA. So those are the 3 big ones. They're the State Department's oversight of the International Traffic in Arms Regulation is certainly something, but that affects the space sector, but it is not space activity per se. So I don't count it.
Well, I'm going to riff off that with Art, because Art, it sounds like from your background, you have been at the front end of various commercial activities in space, starting companies, working with other companies that want to do innovative new things in space, and you're kind of breaking new ground. Laura has mentioned who regulates launch, who regulates satellites in orbit, relating to COM and NOAA's role and all that. But it kind of begs the obvious question, as the U.S. and other countries are talking about going to the moon, which it sounds like you were preparing yourself to take care of regulating or helping to do early on in your career, with the whole Artemis Accords and everything like that. What do you see as a necessary governance structure as this lunar race heats up and we move beyond low Earth orbit?
Well, Les, you know what they say a pioneer is. It's a person with an arrow sticking out of their back. And in a lot of ways, the pioneers that are doing things now are really on a frontier. But we've done it before. We have many different examples. I guess the most powerful one was the settlement by the Europeans of North America. And the question is, what state has jurisdiction? Now, on the International Space Station, I'll just use that as an example. We have an intergovernmental agreement, a executive agreement. And this isn't a treaty. It's an agreement between the nations that work on the space station, and they have various jurisdictions. Now, the jurisdiction for an American registered space object on that registry that is maintained by the State Department, as Laura mentioned, U.S. federal law extends to U.S. registered space objects. So actually on the space station, you could say there's a Russian module, there's an American module, there's a European module, no Chinese modules yet. And there's some agreements about how to deal with that. Now, as for criminal activity, and we have to consider that, I believe it's by the state of nationality on the station. But how do we extend that through cislunar space to the moon? Well, in the short term, we'll probably have some agreements. And I know Mike Gold at NASA has worked up for NASA the Artemis Accords. And the Artemis, being the sister of Apollo, is our moon program today. And these deal with very important issues. The two most important are: who owns the land? Who has jurisdiction over the area that you're sitting in as a space colony or a radio telescope or an ice miner or a space pirate? Who has jurisdiction? Who has the jurisdictions, the power of the court to declare what the law is? It's rooted in power. And the second thing is, who owns all this stuff? Well, now the U.S. has a federal law from 2015 that says that U.S. entities, corporations, individuals, have the right to own resources. And they have the right to sell them and trade them, whatever. By the way, this isn't anything new. It simply states what the law is in the United States in a way so as to remove doubt. So if you go up to the moon now, you are going to operate under American law if you're an American registry. It just happens that Saudi Arabia created a few months ago a Saudi Space Commission. So if you want to register something from Saudi Arabia, you'll be under Saudi law. Or just 2 weeks ago, Costa Rica set up a space agency. They don't have any staffing for it yet, but they've got a space agency. And I guess you'd have to ask if Costa Rica, which doesn't even have a military, would be willing to license you to stay on the moon. Laura mentioned a very interesting point from the standpoint of legal jurisdiction. We have state law that operates. We have state regulatory law that tries to encourage companies to come to states to launch things and to operate and to hire people and to spend money. And so several states have both created federal things like spaceports, which are licensed by the FAA, and they passed laws that say that there's a limitation on liability. But that's a state law, not a federal law. So if you get injured on the way to the spaceport, you're under state law. On the way up, you're under federal law. When you're in orbit, presumably, you could be under state law. And then coming back down, you're under federal law. And then afterwards, say for a tort of not rendering assistance fast enough after you land, you might be under state law again. It has to all be worked out. But in the long run, the people that go into space, if you believe Jeff Bezos, the millions of people that are going to space to create a space infrastructure, they'll at first be under the laws of their country, or they'll be under the laws that they make up as they go along. And we've done that through our whole history of settling new places. As a matter of fact, the Outer Space Treaty that Laura mentioned was a compromise between the United States and the Soviet Union back in the 1960s, the late 60s. And it basically is different than any other in anything else that's ever been done, because it makes a state liable for damage done by their space activities. If I buy a 777 aircraft and I'm flying it and I have all the appropriate licenses and I accidentally crash it into, say, the Kremlin, which could happen, Sheremetyevo Airport isn't that far from Moscow, the US government's not liable for that. I am, and my insurance companies are, but not the US government. But in space, if I drop something from space and it hits the surface of the Earth, there's a no-fault regime that the US government is responsible for the damage that's done. And there's a lot of discussion about what damage is. Now that treaty, that sentence or paragraph in the Outer Space Treaty got developed into a big treaty on liability that has never been used in 40 years. Even when Russia, Soviet Union, dropped an active nuclear reactor on Canada, they didn't use that. That was Cosmos 954. So your guess is as good as mine, Les, as to how those colonists are going to try to govern their lives.
Well, let me ask a question. This could be for either of you to answer. You know, your answer to that question and talking about the legal liability of the U.S. government for activities that might cause damage by U.S. entities and this other law that has never been tested, right? Do you think that legally or philosophically that should give the government the right to regulate all of our space activities, regardless if it falls in any of the regimes that Laura and you have talked about? For instance, space mining, a one-way trip to Alpha Centauri. I mean, I'm just throwing it out there. I mean, does that liability, do you think, give them the reason to regulate?
Well, I think that it is one of the things that that Congress worries about when it's deciding whether to regulate a particular industrial activity that is taking place in space. So, for instance, you see in the Commercial Space Launch Act, which the FAA administers, that Congress told the FAA to make the rocket companies go buy insurance to cover both damage to government property, like at Cape Canaveral, or to third parties, you know, uninvolved people downrange who might get hurt by a launch. And so the Commercial Space Launch Act makes sure that the most likely quantities of damage that might happen are covered by the licensee's insurance. And so that's very useful in terms of apportioning risk to the actual causer of the risk, namely the private entity that is launching the rocket. So that's one thing that goes into it. But I think that the thing that most people feel is the reason that the US government is supposed to regulate activities in space is Article 6 of the Outer Space Treaty, which says first that the nation states that sign on to the treaty are going to be responsible for the acts of their nationals in outer space. And then it says, and shall require, the acts of non-governmental entities shall require authorization and continuing supervision by the appropriate state party. Now, this has led to what, in my view, is a legal error. People read that and they think, oh no, I'm going to start playing the harp on the moon or brush my teeth in orbit, and I don't have a license for that. I can't do it because of Article 6 of the Outer Space Treaty. This is legally incorrect. That provision requires, in our system, you know, our Constitution says we have 3 branches of government. Congress passes the laws, the executive branch carries it out, and the judicial system says whether the other 2 got it wrong. But when a treaty says, oh, you need to have laws, well, under our system, who writes the laws? Congress. So if Congress has not passed the law saying that a lunar habitat or playing the harp or brewing beer on the moon requires a license, then a US citizen does not need a license. If Congress passes a law saying you do, then you will need a license. But right now, under Supreme Court law dating back to the beginning of the Republic up to 2008, when a treaty is not self-executing, and this provision is not, then the private sector can go on doing what it's doing, just like I can go in my backyard and have a barbecue without a federal license. They can go set up a habitat on the moon without a federal license. This is my legal opinion. It has not been tested in court. So, that matters. But I think I'm reading the law correctly, and this is important. But Article 6 of the Outer Space Treaty is why people think that any private activity in outer space has to be regulated. But it's wrong.
Art, do you agree?
I would like to, first of all, concur in my colleague's legal analysis, and I've looked at it very carefully. A couple of years ago, I'm an academician of the International Academy of Astronautics, and this is a group of people from all over the world. They're not just Americans. They're, as a matter of fact, Americans are a small minority, but they are leaders in their field, and they do studies. And so I edited a study for space mineral resources, the use of space mineral resources. First time there'd been a study of this kind. And the legal part was by far the most important part of this study. And so we looked at these questions in detail. Article 6 of the Outer Space Treaty has been followed up by a General Assembly resolution of the United Nations, which, while it's non-binding, indicates the international view on this. And that resolution states that states have an obligation to take and put into place some form of regulation according to their laws. So it's national law that will control activities in outer space. Now, for Americans, that's particularly wonderful because the American government doesn't have general powers. You ever think about that? The British government does. The 1986 Outer Space Act in Great Britain says that the Home Secretary, I think now it's the British Space Agency, has the right to regulate any activity in outer space. They have the right to, they don't have the obligation to. So if you want to play chess with an alien, you might have to get a British license. But in the United States, our federal government only has delegated powers. It doesn't have general powers. And so if something isn't controlled by the Constitution or a federal law made pursuant to the Constitution, then Article 10 of our Constitution states that the rights are reserved to the states or to the people. So if it isn't against the law, we can do it. And that's the backyard barbecue that you mentioned. Now, this is wonderful, but a lot of people in Europe and Russia and China and other places don't like the idea of American individuals and corporations doing what they want to do without having a great deal of oversight. And my feeling for them is that I'm so sorry, fellas, that's how our government works.
Well, I guess, just as an observer to this, I think when you delegate things to individual nation states and their laws to be the governance, and you don't do due diligence of understanding how those nation states do their laws and do governance, you get what you get, and they've got what they got with our laws, right? So that's a good thing.
Yeah, because one thing to remember is that the U.S. Constitution overrides a treaty.
Oh, that is terrible.
The treaty is not delegating any kind of powers to the United States. The treaty's log is on par with the congressional law, but it is not. It does not trump the First Amendment or other provisions of the Constitution. So, just like other countries, the United States Constitution prevails in interpreting a treaty.
Well, some countries aren't like that. In Europe, for example, the national law is the supreme will of the legislature, and the legislature consents to the treaty, and therefore it's the supreme law. we wouldn't be happy with that.
Well, we have this little tricky confusion in the Constitution itself, which says that treaties are the law of the land. But again, only for those parts of them that are self-executing. And, this came up very, very early in the history of the Republic, and it's been litigated again. So I think we're clear.
Laura, I was at an International Institute of Space Law colloquium in Rome, and I had developed a paper on this where I went through and proved what you just said. And when I got up and delivered my paper, this is 20 years ago, the Soviet delegate interrupted me, stood up and said, "That cannot be right. No nation can ignore a treaty." And I thought, my goodness, fellow, you don't think that the Soviet Union's ever ignored a treaty? And he came up to me in the cocktail party afterwards and said, "Art, could you get me a book on American constitutional law?"
Well, this is one of my pet peeves where people like to use the Outer Space Treaty as speaking in metaphors, as saying that, oh, it's the Constitution of outer space. It's not. It's an agreement between nation states that any of them can back out of.
Oh, it's a Faustian compromise between the fact that the Soviet Union was afraid that space would be sullied by capitalism, and the United States was afraid that Russia, the Soviet Union, would claim the moon, would claim ownership of the moon.
Right.
And it's about as useful as the treaty that divided the New World between Spain and Portugal. Meanwhile, the English, being left out of that, simply went out and settled North America.
Well, I guess that brings up something, and Art, I know your connection with Heinlein, and I recently reread a great book, "The Moon is a Harsh Mistress," and the whole notion of who's going to control independent peoples when they're out there, anywhere. Out there could be an asteroid, it could be the moon, it could be Mars. Ultimately, it's going to be decided, I believe, I'm not a lawyer, I think it's going to be decided by the people who are there, or else someone will have to exert force to do that over them, right? I mean, what is the thinking on that? I mean, if you had to look to the future, do you see a patchwork of laws continuing to govern things as we establish settlements on some of these worlds and we're mining asteroids, or do you see a nativist law coming along and having precedence over that? Where do you think we're going?
You want me to take that, Laura, or you want to take it?
I use, but you go first, and I'll follow up.
Go first, and I'll keep it short. Law is force. Period. Full stop. Jurisdiction is the power to declare, for the court to declare what the law is, and it's backed up by force. So long as you don't have force to back up a legal judgment, it is kind of a common law that may be accepted or may not be accepted, or people will argue about it. I believe that the law will organically evolve to deal with all of these issues. The most important thing is that we try to avoid warfare, because humanity only has two ways to settle problems. One is law, and the other is war. That's it. And so I'm in favor of a good U.S. heliocentric fleet, making sure that the court's judgments are enforced.
I think that one of the things we need to think about when we start looking at nativist laws is that as a science fiction community, we think the future's here, but it isn't. And I think we need to be careful about that, because I don't think we're going to have nativist laws, rebellion on the moon, what have you, the moon is a harsh mistress, until one really important factor is in place, and that's a degree of self-sufficiency for those peoples that are just not on the horizon right now. Instead, we're going to have a couple of corporations who may be squabbling over the peak of eternal light, and they are going to go and sue each other in court here on Earth on the ground. And that will be where the dispute gets resolved. Or if someone, tries to launch, if an American tries to launch without an FAA license from Brazil, and then has to resupply the colonists that it sent up, there's going to be problems because the FAA will be issuing civil penalties and they have assets that can be attached. There's a whole body of law where you can, get the guy by banks, through extradition, all sorts of different things that do not leave you, merrily running away and having your own kingdom on some other planet. Right now, anyone up there is going to be tied to Earth for decades, if not centuries to come, and can be controlled by the law that is here, as Art would say, a matter of force. So, so I think it's going to be quite a while, but I do agree that eventually, organically, we will see some changes because how could you not? So those are my 2 cents.
I'd like to take us on a question that I get asked a lot, and it's because it pops up in the news all the time, and that is the problem of cleaning up orbital debris. The orbital debris problem has been caused since the beginning of the space age, a lot of carelessness, some accidents, some deliberate malfeasance of putting space junk in orbit, traveling at 8 kilometers a second, which means if it hits you, it's going to do damage, right? And at the last count, there is about 500,000 pieces of debris the size of a pea or larger that are orbiting the Earth in various orbital slots that are endangering spacecraft. There was news this week that the space station took another hit by a small piece of debris. So I've been involved in my day job, which I'm not representing here. I'm just citing something we looked at, which is how you would go up and pick up pieces of junk and get rid of them. And that brings up the whole question of, wait a minute, one person's junk is somebody else's spacecraft or somebody else's property, right? And so when it comes to cleaning up orbital debris, which I think a lot of people would say is a real problem, and we might need to think about doing that, how feasible is this? Not from a technical point of view. I can come up with technical solutions, but how feasible is it to go do that, given we don't necessarily know what all these pieces are, where they originated, who somebody's junk is, and who somebody's intellectual property might be that they don't want you recovering and reverse engineering. Is there anything out there on that is the current thinking?
I've written a book.
Well, I didn't know that, actually. This is not a setup. This is
no. It's a science fiction novel, but in it I posit a prize offered by the Consortium of Man, which is imaginary, but it is located on the Isle of Man, of $50 million in gold to whoever can first bring in a large piece of space. I've worked on a lot of orbital debris regulations, so I was very interested in this. This is a while ago I wrote this one, and the way I see it is the people who are in the competition to win this prize, they're going to have all their different technical approaches, but they are going to have to purchase the dead piece of debris from its owner, because we have a lot up there that is large and intact, just waiting to be hit and become smaller and even deadlier. And so they're going to have to go pay $10 or $1,000 or whatever to take it off these people's hand and bring it in and drop it in the ocean by whatever technical means they have devised. Now, as for all the smaller stuff, I know that lots of people say you can't have salvage in space, but you're going to have little pieces, right? We can see the stuff up to 10 centimeters. So that could be scooped up under the laws of salvage, and that's a long argument to make, but I think it's a doable thing. And when you get into the intellectual property or the national security considerations of the owners of these objects, you're going to find some people more willing to sell them and others less so, and you may have trouble getting the specs to look at for when you attach yourself to the object. But there are regulations in place, both from the FAA, the FCC, and NOAA for mitigation, not for remediation, but for mitigation, for preventing it from happening in the first place for those areas where they have jurisdiction.
Art, did you have
Personally, I
anything
think
to
right
add to
now
that?
oops, sorry, didn't mean to speak over you, Les.
No, go ahead. I was going to pass the ball to you if you had something to add.
I thought you might be doing that, but I spoke at the same time you did. I apologize. Of course, Laura's right. We need to mitigate, we need to avoid, we need to have rules that say it naturally deorbits in 25 years or less, which I think we have now. That's the regime now, isn't it? It's 25 years and try to avoid it, through engineering.
Not
Laura,
yet.
is it still that?
Not for the commercial. It's a governmental requirement for DOD and NASA.
Yes.
If you ignore all the waivers.
Yes, if you ignore all the waivers, of course.
But it is on their books.
The real problem is that, if you mentioned, there is no space salvage. You don't lose title to something simply because it's in space. As a country, I presume, on the registry of the U.S., the upper stages still belong to whoever owned them, the government, the private companies. Now you can buy them. I've negotiated for the title to upper stages that are dead because people wanted to go up there and grab them and take them apart and use them for things. Like they have rocket engines on them and pressure vessels that you could make into things. And NanoRex has been studying that, among others. So it's really a resource. If you figure out a way to make it profitable to clean up space debris, it'll be cleaned up and it'll be nice and shiny, because profit moves industry. Whereas if you just make it a regulation, you'll have a lot of waivers.
One of the other things I wanted to ask you is, and I think people would be curious about this, there's been a lot of talk, and a lot of them have come and gone, space mining companies, right? I mean, we were all excited a few years ago when a couple of these companies stood up and said they were going to go pioneer space mining, and we haven't heard from many of them recently, and I think more than one has disbanded. I know that in Europe, I'm forgotten exactly which country it is. It's one of the smaller countries has decided to set it. What's that?
Luxembourg.
Luxembourg. I was going to say that, but I wasn't sure, and I didn't want to name it. It's setting itself up as like we're the go-to country if you want to go do space mining, right? So I guess the question I have to ask is, if if I get some big investor to bankroll my space mining company because I have a great widget that's going to allow me to extract something that somebody wants to make lots and lots of money, how do I go lay a claim?
Say again?
How do I go lay a claim? Let's say I want to go to asteroid 1991 VG, just to pick one out, because I happen to be leading a mission that's going to go take pictures of something like that. How would I stake a claim out and say, I want this asteroid, I'm going to mine it?
Well, let me give that a crack, because I did the space mining book. And nobody knows for sure, and it won't be determined until the courts rule. Even then, you have to determine what country you're talking about. But all of that is a risk factor. And you have legal risk factors. That's why the 2015 law was passed, to eliminate a legal risk factor. So we can definitely say U.S. entities can own things, extracted minerals, extracted regolith metals from asteroids. And Luxembourg has similar laws. Only in Luxembourg, you don't have to be from Luxembourg. You just have to have a Luxembourg company. Every single person in that company could be from somewhere else. And that's a nice way to set it up. Luxembourg also put 200 million euros into capital investment. Some of it went to Planetary Resources, where they promptly went bankrupt. The first two companies went bankrupt. The third one I incorporated, and I folded it back into my existing company because it wasn't time for space mining yet. But remember, I'm a patent attorney. I know, because I'm working on patent applications that I can't tell you about, that there are very advanced mining methods that are presently being patented. We're in the period of time when we're developing the technology to do all this stuff. And I'd like to return to that later, but I'd like to have Laura address this now.
Well, Les, there is no formal mechanism for staking a claim. I would, if it were me, I would rely on principles of adverse possession, which go back to, medieval times and have stood us in good stead. for disputes between neighbors in suburban America. And you can, incrementally over a set number of years, by possession, which is open and notorious and, known to all, take possession of something. And so if you satisfy all those elements, you could perhaps then go into court, and let's say that Maryland has 15 years for adverse possession, and maybe say, hey, I've been on this asteroid for 15 years working it, no one else is there, I want you to recognize it's mine. I'd give that a go. Would it work? I have no idea. But you might give that a go until you can get federal legislation passed. And if you were doing that work, I think Congress might listen to you and might agree with you that possession counted for something, especially since you've been very publicly possessing it and working it and selling it. And that is a path, I think, that is going to turn out to be the most fruitful one.
Well, I think so far in the panel, you've each given me what I would consider the tagline for the panel. Laura just gave one, which is, I would go for it. And the other one was from Art, where he said, of course, Laura is right. And I can see T-shirts popping up with that on it. So I think those are great taglines for where this panel has gone, because it sounds like that from the novice point of view, is that in the near term, we're going to be continuing to have the existing legal frameworks for Americans anyway that are in U.S. law, right, when it applies to outer space, regardless of what other countries think about it.
Right.
Is what I get from that, and that's interesting. And I'm just going to give a quick anecdotal story. I attended a space law lecture at the International Space University a few years ago. I attended that program in their summer program many years ago, and I go back and lecture, but I sat in on a lecture on space law. And to my great surprise, this topic of ownership of property in outer space was the topic of that day. Ownership of anything, extracted, whatever. And it was the overwhelming sentiment of the students, with the exception of the American students and the Australian students, that basically no one should be allowed to make any money in space. And that really terrified me.
Yes.
Because of my American sensibilities. But I also know that the history of doing anything involves people being motivated by money. And as someone who's a space advocate and wants to see the human species expand into space, if you take away the profit motive, I think we're going to be forever confined to planet Earth. I don't know if you have thoughts about that.
Yeah. No, I think that money is the great incentive. And why would you want to punish people who are doing something you want them to do by telling them they can't make money? Money is such a peaceful way of interacting with other people. You've normalized all sorts of transactions, and you've got a voluntary arrangement. No one's shooting you. It's great. It's really great stuff.
Well, everybody gets to make up 3 laws, Clark's laws, Newton's laws, Copernicus's laws. I have a Dula's law, and that's that which is owned by everybody in common is developed by nobody in particular. Mm-hmm. And it's really true. I was the first space lawyer for the International Space University at its founding. I was the law professor. I still have my certificate that they gave me for it. It was at MIT. Now, the fact is that I run into this all the time at international meetings. But there is a way out of it. And that way out of it is, first of all, for nations to promulgate laws like the United States has, and say, under our national law, this is allowed. Well, under Russia and China's national law, it's not allowed. And even in England, a nice civilized country, the Queen owns all the gold and silver that's in the ground. And in Mexico, the state owns all the oil. So if oil is discovered on your land in Mexico, it's hideous because they throw you off and you drill for oil, the state does. I think that the people that get up there first, whether they're Chinese or American, that they'll set up their laws for what they do because it's national law that's going to control this. And in America, you can do anything that isn't illegal. So we just have to be careful not to over-regulate it. I think the FAA's done a good job of that on launching.
Well, as we're close to the end of the time we have, I'd like to do two things. The first is I'd like to come back to each of you if you have any closing comments for science fiction fans in particular about the way that we think about the future and how this notion of space law can play into this vision of the human expansion into the cosmos, right? Dream big, right? And then after you each maybe make that comment, we'll go back and we'll close out with giving each of you an opportunity to maybe plug any books or activities that you've got coming up. Because I know this group is a bunch of avid readers, and I think I've heard both of you say you've written books, and I'd like to give you the opportunity to do that. So why don't we start out, if we could, with Laura. And do you have any closing comments for science fiction fans about space law and where we're going with all this?
Well, for those of you who are thinking of law school, space law is a fascinating field. But for those of you who aren't, I'd sort of like to develop a little bit what we were just talking about with respect to property rights. I think property rights are a fundamental human right that allows for the development of many new things where people are peaceably rewarded, and they are to be encouraged. And so if ever you go into politics or you have reason to advocate for the recognition of property rights in space, I think it's a good thing to do.
Well, yes. All you science fiction people out there, I'm one of you, and I'm a patent attorney. And in the last 2 years, I have gotten issued 2 patents on ways to transfer momentum out of the ground state of the electromagnetic ground state, the EM ground state. Now, these are really difficult patents to read because they're full of quantum mechanics and mathematics. But if they're correct, we won't be using rockets much longer, because this is the way Robert Heinlein said that his spaceship worked. They couple directly into the physical structure of space-time to transfer momentum. I invite you to try to find those patents. And I'm an inventor on one of them, so it shouldn't be too much trouble. But the main thing is, it's not going to take as long as you think. We think in a linear fashion. Events happen in an exponential fashion. There are ways to do things to settle the solar system, to mine everything, that can let 10 trillion people live at a standard of living that's twice that of the United States today. And if you would like to know more about that, I invite you to listen to my presentation, which I recorded a day or so ago, that has all of the economics and statistics and graphs and charts and so on. Good luck with that. But I sure do appreciate being able to talk about this to some people that like science fiction.
Thanks, Art. Now, this is your opportunity to shamelessly plug your work. Laura?
Well, thank you, Les. Okay, let's see. Shameless plugging, where to begin? So I have written 9 or 10 novels and a handful of short stories, novelettes, and they're all available on Amazon in ebook and paperback. And the Waking Lake trilogy is available in audiobook from Podium Publishing. And let's see, the space opera is my more popular works, and that is set on the planet of Nulf, which is a lost colony world. The space people, they use acronyms, so that stands for not what we were looking for, because they were wound up in the wrong place. And so they have a small terraformed valley, and they're working to keep it going because the rest of Nulf, weighs in on them. And the first of those books that I wrote was called Sleeping Duty, in which our space marine is awakened after 300 years of cold sleep. And the king, there's now a king, won't let him awaken his wife. And so that's the trilogy that's on audiobook. And then on the bourgeois legal science fiction side, I have books like Manx Prize, which are about the prize to deorbit, and Mercenary Calling, which is lots of space lawyers dealing with planetary protection issues, because in that one, an illegal settlement was left on a new world, and our hero has to defend the starship captain on grounds of mutiny. So those are my books, and my new series is Martha's Sons, which is set in the early days of Newell's settlement as technology decays and civilization crumbles, which is, cheery.
Nice upbeat stuff.
Yes.
Art, what about you?
Well, first of all, I endorse Laura's books. I've now read a couple of them, and I liked them. They were good, and I speak at Cathedra, being the literary executor of Robert Heinlein. She did a good job on them. They're worth buying, so go out and buy them. The book that I edited for the International Academy of Astronautics is called Space Mineral Resources. And it's a desk encyclopedia about 2 inches thick that goes into the technology, the policy, the law in detail. It has business plans from all the companies that announced, and it offers a way forward. So you can buy it at Amazon, and it's not very expensive. We also published in the Heinlein Trust, we published the complete works of Robert Heinlein in 46 volumes, leather-bound, numbered. Get them before they run out because it's a limited edition. It's $1,500, which is pretty cheap for a limited edition of everything Heinlein ever wrote, plus all of his letters. But we also published a couple of books because they had to be published. One of them was the Space Mineral Resources book that I just mentioned, that we published in cooperation with the International Academy of Astronautics. Another one was Space Solar Power, and another one was Space Elevators, because we deemed these to be the absolutely critical technologies necessary to take a human civilization into cislunar space. And it's been overtaken by events because of those patents I just mentioned. I hope that you'll look for them because they're magic. Any advanced technology is indistinguishable from magic. I think somebody said that.
Somebody famous. And it was Art Dula tonight. So
no, it was Arthur C. Clarke.
It was Arthur C. Clarke. That's right. I didn't know if I could mention him to someone who is part of the Heinlein Foundation, right? Well, I'd like to close this by doing my own shameless plug. I'm Les Johnson. I'm the moderator for this panel, LibertyCon 2021 panel on the regulation of space activities. I'm also a writer. I write popular science and science fiction books. I've got several books coming out this year. It's a big year for me, 2021. My next novel with Travis Taylor is coming out in hardcover in August. It's the first book of a 3-book series in a new universe, and the book is called Saving Proxima, and it's a novel of first contact with an alien civilization. We hope you join us to go along the ride with that. And like Laura, I've delved into space opera for the first time, leaving the hard science fiction of Saving Proxima for starting a new series called The Space-Time War. And that'll be out from Baen Books in October. And sandwiched between the two, they are reprinting an anthology that I co-edited with the great Jack McDevitt called Going Interstellar, which has a collection of original science fiction stories from various authors interspersed with popular science nonfiction about how we might really go to the stars. So I would encourage you to visit your favorite bookseller. It sounds like most of the books that mine I know are available on Amazon, Barnes & Noble, directly from Baen, and at small booksellers and paperback or hardcover. It sounds like Laura's are widely available online at Amazon, and Art's are as well. You can visit my website, lesjohnsonauthor.com, and enjoy LibertyCon.